Have you ever had a neighbor that just drives you up the wall? Someone who's a little too loud, a little too often. Well, today we're going to dig into what the law actually says you can do about it. So let's just get right to it. The big question. Can you really take your neighbor to court just because they're annoying? And you might be surprised to hear that the answer isn't a simple yes or no. It's actually got a whole legal framework, and we're about to break it down. Okay, to make this real, let's set a scene. Picture it. You've got a new neighbor, and this neighbor has decided that 2 in the morning is the absolute best time to practice their drum solos. And we're not talking about a one-time thing. This is happening every single night. Your windows are rattling, you can't sleep, you're basically at your breaking point. Now, you've tried to be the good guy, right? You've asked them nicely, maybe you've even begged them to stop, but they just won't. So you're stuck. You're exhausted, frustrated, and feeling totally helpless. What are your options? What can you actually do, legally speaking? Well, this is where a pretty cool legal concept called private nuisance enters the picture. You can think of it as the law's specific tool designed to protect your right to just have some peace and quiet in your own home. So what is it exactly? In legal terms, a private nuisance is a claim you can make when there's a substantial and unreasonable interference with your property. And I'm telling you, those two words, substantial and unreasonable, are absolutely everything. The entire case hinges on them. Okay, so check this out. This flowchart right here, this is going to be our legal roadmap. We're going to follow it step by step to figure out if our 2 a.m. drummer problem actually stands up in court as a private nuisance. All right, first stop on our map. Before we get anywhere, we have to clear the very first hurdle, and that's proving the interference is substantial. So let's apply it to our situation. Is having a drum kit blasting through your walls every night at 2 in the morning a substantial interference? Well, to answer that, we have to know what the law means by substantial. And here's the key. The law doesn't care about someone who's, super sensitive. It uses a normal person standard. We're not talking about a neighbor's dog barking once or a garage door opening. A substantial interference is something that an average, reasonable person would find seriously offensive or inconvenient. So, nightly 2 a.m. drumming? Yeah, that's going to clear this bar. Easy. Okay, so we've established the drumming is substantial. Great. But that's only half the battle. Now we come to the second, and honestly, much trickier hurdle. Is the interference unreasonable? And let me tell you, this is where these cases are truly won or lost. Figuring out if something is unreasonable isn't just a simple checkbox. It's a much deeper question. So how does a court even begin to decide what's unreasonable? This is where the law gets really fascinating. It does a balancing act. It literally puts the harm you're dealing with on one side of a scale and the value or usefulness of what your neighbor is doing on the other. We're going to call this the Great Balancing Act. This is the core of the whole thing. We're going to directly compare the damage done to you against any good reason your neighbor has for their actions. So let's picture that scale. On one side, we're piling up everything bad that's happening to you, what the law calls the gravity of the harm. And on the other side, we're putting all the reasons your neighbor is doing this in the first place, the utility of the conduct. So first, let's load up your side of the scale. With the drummer, the harm is serious. We're talking about constant loss of sleep. That affects your health, it affects your job, and at its core, it's a total violation of the peace you're supposed to have in your own house. That's some heavy stuff. Okay, now for their side. What's the utility for our drummer? Well, you've got artistic expression, that's a valid thing. They're practicing a skill, which has value, and they're getting personal enjoyment out of it. And these are all legitimate things to do. So here it is. This is the question the court has to answer. Which side of that scale tips? Does the drummer's freedom to practice their hobby at 2 a.m. outweigh your fundamental right to sleep? So let's put all the pieces together and see where our legal roadmap has taken us. We've gone through both hurdles, we've weighed both sides of the scale. What's the verdict? Well, when you actually weigh it all out, the answer becomes pretty clear. A court is very likely to find that the severe harm of losing sleep every single night is much heavier than the benefit of practicing drums specifically at 2 in the morning. That makes the interference unreasonable. And once you've proven it's both substantial and unreasonable, you've got yourself a solid case for private nuisance. So if you're ever in this situation, here's what you need to remember. Just think of it as a simple 3-step check. Number 1, is the interference substantial? Is it more than just a minor annoyance? Number 2, is it unreasonable? And to figure that out, you go to step 3. You balance the harm it's causing you against the benefit it's providing them.
In the end, this whole legal idea is really trying to answer a much bigger question, isn't it? Where exactly do we draw the line between one person's right to do what they want on their property and the community's right to have some peace? It's a delicate balance, and it's something to think about the next time things get a little noisy next door.